All right, good morning, everyone. Let's go ahead and get started. We are now live on YouTube. Let's get started with today's docket. I'll take quick announcements from any attorney who has a quick announcement today. We'll start off with quick announcements before taking our docket. If you have a quick announcement, please raise your hand to let me know that you're ready to have your case called. If there's no quick announcements, Mr. Medina, who do you have?
Judge, well, we have a status, and from the plaintiff's perspective, we're going to announce ready. And I believe Memo has a motion to reconsider. I think those are the only two issues that we have this morning.
This is CL 193702H, Ruben Duran versus Dorothy Gott.
Yes, Raul Medina for the record, Your Honor.
And Judge, Memo is in Judge Noe's court right now. He asked if you called his case, if you could recall it later.
Okay, do you know or have any idea how long that's going to take, Mr. Denzer?
I do not know. He was in that hearing already when he called me a little while ago.
Okay. Mr. Medina, so this is a mandatory status conference. You're announcing ready for trial?
Yes, Judge. I believe we're set for trial January 31st, I think it is.
So ready. I'm going to put you down as ready. And I mean, I don't want to, do you have anything else, Mr. Medina, this morning? I don't want to keep you waiting if it's going to take Memo, half the morning.
Right.
Announcing ready. It's his motion to reconsider. I can maybe call this later in the week.
Judge, this is the only matter that I have, but I'm willing to wait for Memo for a little bit. I think his motion to reconsider shouldn't take us but a couple of minutes.
Okay, no problem. Then if you don't mind hanging tight, please.
All right. Thank you, Your Honor.
Thank you.
Thank you, Judge.
All right, thanks. Mr. Solis, David.
Good morning, Your Honor. Mr. Judge, on the other side, it's CL-20-2651-8.
All right, this is a status conference hearing on a motion to stay.
That's correct,
Yep.
Your Honor.
All right.
Yes,
Whose motion is this?
It's a status hearing. I believe it was Mr. Denzer's predecessor who filed the motion to stay. Mr. Denzer subsequently filed a notice of appearance, but I think the stay has been lifted.
Oh, okay. Okay.
that's right. There's no stay anymore. The Guarantee Association is just trying to verify documents. On this case, I was able to talk to the adjuster this last week. Mr. Solis provided some documentation. They needed a few more documents, so I need to talk to him about that. But if we could get another status, that would be helpful.
Does this case have a trial docket or trial?
It does, Your Honor, 5/9/2022, but we're probably need to get a continuance on that. I haven't discussed this with Mr. Denzer, but I know we haven't even done depositions, much less mediation.
You want me to give you a new DCC now to try to put you as quickly as possible, or do you want to just continue at course as usual and then we'll cross that bridge in May?
I'm okay with the new DCC, but while reviewing my notes, I did notice that in Court 10, there was another case pending. I don't know if a motion to consolidate was filed or was going to be filed. Nick, do you know anything about that?
No, I know it's pending, and that's all I have in my notes as well, David.
So I guess we'll take a new DCC, Judge.
Okay. Give me a new DCC.
So do the 19th of January. 3:30.
January 19th, gentlemen, at 3:30 p.m.
All right.
I don't have any other further business, Judge. May be excused.
You're excused. Thank you so much, Mr.
Happy
Denzer.
New Year.
Likewise, Mr. Denzer, are you going to hang tight for Memo, or do you have another case?
I can hang tight. I also have one more status with Rogelio Garza, but I'm on my phone, so I can't tell who all's in the hearing.
Mr. Garza is on. Let me see. Where did I?
Yes,
Okay.
good morning, Your Honor.
Good morning. All right.
It's CL 20-3085H.
All right. That is David Anthony Salazar versus Diana Laura Guerrero Riojas.
This is another bankruptcy case, Your Honor. So Mr. Denzer can, I guess, give me an update.
I wish I could. This one I haven't been able to get a hold of anyone on the other with the Guarantee Association to figure out what's going on. I need to keep following up, but they got a ton of cases with ACCC going out of business, and a lot of the adjusters have kind of left, and they keep reassigning stuff. So I don't have an update for Mr. Garza or the court, but another status hearing or DCC would be fine. I don't believe we have a trial date.
Mr. Garza, is the DCC okay with you?
I believe it is in order. Yes, Your Honor.
January 18th at 2:30. January 18th at 2:30.
All right, thank you, Judge.
You're welcome.
I'll text Memo and see the status with him.
Perfect. Thank you so much. Mr. Garza, do you have anything else before the court?
Yes, Your Honor. I have CL 20-1570-H, Monica Marie Rodriguez versus Eugenio Sanchez. I don't know if the defense counsel is on either. It's Sonia Salinas Cerda.
All right. Is anyone here for Eugenio Sanchez? Sonia Cerda, is anyone here on that case? It's a mandatory trial status conference. Trials set for the latter part of this month.
That is correct, Your Honor. And we are set for a mediation this Friday.
All right, mediation Friday. And this Friday is the, what's the date on that? That's maybe like this.
14th, I believe. 14th.
All right, and then, so we've got docket call on the 27th. All other considerations left equal, you are ready if this case doesn't settle at mediation, Mr. Garza?
That's correct, Your Honor. At this time, that would be the announcement.
Okay, great. I'm gonna put you down as ready then.
Okay.
Okay, sounds good.
Thank you.
We'll see you on the 27th at 1:30.
Thank you, Your Honor. I may be excused.
You're excused.
Thank you.
All right. Anyone else with an announcement, a quick announcement? I'll take any quick announcements before I take Monica.
Judge, it's a quick final hearing. There's no respondent, there's no kids, there's no property. It's just a final prove-up. If
Okay.
you can take our case.
Sure, this is F-36-73-21-8 in the matter of the marriage of Victoria Diaz and Mark Anthony Chapa.
Your Honor, Monica Galvan here on behalf of Victoria Diaz, and Ms. Diaz is on the screen. She is the petitioner in this case. I'm asking that the court take judicial notice of the filings, including the waiver of service filed on behalf of Mark Chapa.
The court will take judicial notice of all documents in the court's file. If I can have Ms. Diaz please raise her right hand. Do you sort of tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you. Ms. Galvan, you may proceed.
Yes. Would you please state your name for the record?
Victoria Elena Diaz?
And Ms. Diaz, are you currently married to Mark Chapa?
Yes.
Okay. And Ms. Diaz, were you married to Mr. Chapa on or about September 28th, 2012?
Yes.
And you separated on or about March 9th, 2021?
Yes.
And you filed this petition for divorce because the marriage has become insupportable because of discord or conflict of personalities that destroy the legitimate ends of the marriage?
Yes.
And Ms. Diaz, there is no property involved in this case. You're each taking your own debt, is that correct?
Yes.
And you're each taking whatever assets you have in your possession?
Yes.
Ms. Diaz, are you currently expecting a child?
No.
Are there any children of this marriage?
No.
And are you asking for a name change?
No.
Your Honor, at this time, we're asking that the court, are you asking the court approve a divorce, a final divorce between you and Mark Chapa?
Yes.
Your Honor, that's all I have for Ms. Diaz, and we're asking that you approve this final divorce decree.
Court's going to go ahead and grant the divorce along with all relief that's been read into the record and prayed for by way of pleadings. I don't have an order on file, Ms. Galvan. I suspect that you will be submitting one here shortly.
Yes, Your Honor, we'll submit it today. My assistant who's handling this case is out sick, but if not today, by tomorrow. We already have all the divorce decree finalized with the signature, so we will get it submitted.
Sounds good. Thank you so much. Ms. Diaz, stay in contact with Ms. Galvan and her office. As soon as that order is submitted for my signature, I'll sign it and you can get a certified copy, okay?
Okay, thank you.
Thank
Thank you,
you.
Judge. May we be excused?
Both of you all are excused. Have a good day.
Thank you. You
You
too.
too.
Bye-bye.
Mr. McLaughlin, what do you have?
I have 4 motions for default judgment.
All right, let's go ahead and call, I suspect they're all from portfolio or some of them are?
3 of them are from portfolio. 1 is con appliances.
Perfect. Let's start with the first one, CL 185955H, Portfolio Recovery Associates versus Claudia Torres. Is Claudia Torres present? Claudia Torres? Claudia Torres. Name of Claudia Torres was called out 3 times. Court will take judicial notice of all documents in the court's file, including the filing of this action on October the 9th, 2018. Citation was issued October 11th, 2018. Defendant was served October 26th, 2018. The citation was returned on October 30th, 2018. To date, there's been no answer on file. This case has been on file for 1,187 days. You may proceed with your default.
Yes, sir. In this case, we believe that Ms. Torres had opened up a Walmart credit card. It was opened on December 27th of 2015. She made her last payment on September 16th of 2016. The account was subsequently closed and charged off with a balance of $1,707.73. We're seeking that amount in damages plus costs of the court and post-judgment interest, and would ask the court to take notice of the business records affidavit, the non-military declaration, and certificate of last known address, and issue judgment for the plaintiff.
Court will go ahead and take judicial notice of all documents the court's filed. The court's going to go ahead and grant relief and judgment in favor of the plaintiff and against the defendant. That relief is granted.
Thank you, sir.
Let's go ahead and call CL 186540H, Cons Appliances, doing business as Cons versus Gloria Luna. Gloria Luna. Gloria Luna. Name of Gloria E. Luna was called out 3 times. There being no response, the court will take judicial notice of all documents in the court's file, including the filing of this action on November 13th, 2018. Citation was issued November 13th, 2018. Defendant was served November 27th, 2018. It was returned to the clerk on December 3rd, 2018. It's been on file for the requisite period of time. There's been no answer on file. This case has been pending for 1,151 days. You may proceed with your default.
In this case, Your Honor, we believe that the defendant had opened up a installment contract with Cons Appliances on October 12th of 2014. They made their last payment on April 4th of 2016. The account was closed and charged off with a balance of $1,563.26. We're seeking that amount in damages plus costs to the court and statutory interest of 5%, and would ask court to take notice of the business records affidavit, the non-military declaration, certificate of last known address, and issue judgment for the plaintiff.
Court will go ahead and grant judgment in the principal amount of $1,563.26 plus cost of court and post-judgment interest in the amount of 5%. That relief is granted.
Thank you, sir.
Court's going to go ahead and call CL 186576H, Portfolio Recovery Associates, LLC versus Elia Briones Garza. Elia Briones Garza. Elia Briones Garza. Name of Elia Briones Garza was called out 3 times. There being no response, court will take judicial notice of all documents in the court's file, including the filing of this action on November 14th, 2018. Citation was issued November 19th, 2018. Defendant was served December 3rd, 2018. It was returned to the clerk on December 4th, 2018. To date, there's been no answer on file. This case has been pending for 1,150 days. There being no answer on file, you may proceed with your default.
Yes, sir. In this case, we believe that the defendant had opened up a Visa credit card with IBC Bank. It was opened on March 1st of 2015. She made her last payment on August 2nd of 2016. The account was closed and charged off with a balance of $2,462.45. We're seeking that amount in damages plus costs of the court, and would ask the court to take notice of the business records affidavit, the non-military declaration, certificate of last known address, and issue judgment for the plaintiff.
Court will take judicial notice of all those documents. Court's going to go ahead and grant judgment in the principal amount of $2,462.45 plus cost of court. That relief is granted.
Thank you, sir.
And the last one you have is CL 186892H, Portfolio Recovery Associates LLC versus Macarena Ramirez Perez. Macarena Ramirez Perez. Macarena Ramirez Perez. Name was called out 3 times. There being no response, court will take judicial notice of all documents in the court's file, including the filing of this action on December the 5th, 2018. Citation was issued December 6th, 2018. Defendant was served December 15th, 2018. It was returned to the clerk December 17th, 2018. To date, there's been no answer on file. This case has been pending for 1,129 days. You may proceed with your default.
Yes, sir. In this case, we believe that the defendant had opened up a credit account with Capital One Bank. It was opened on June 9th of 2016, and she made her last payment on June 1st of 2017 and the account was subsequently closed and charged off with a balance of $2,489.16. We're seeking that amount in damages plus costs to the court, and would ask the court to take notice of the business records affidavit, the non-military declaration, certificate of last known address, and issue judgment for the plaintiff.
Court will go ahead and grant, will take judicial notice of all documents in the court's file. The court will go ahead and grant default in the principal amount of $2,489.16 plus cost of court. That relief is granted.
Thank you, sir.
Thank you. Do you have anything else?
No, sir. May I be excused?
You're excused.
You have a great day.
You too. Thank you. All right. Mr. Tijerina, I know that I see Mr. Medina here and Mr. Denzer was waiting, your colleague. I know that, let me just see if I can call out Mr. Medina to see if he's available real quick. He did say that he didn't anticipate our hearing to last very long. He did announce ready for trial. Mr. Medina, can you hear me? If you can hear me, I'd like to hear your case real quick. If not, Mr. Tijerina, if you don't mind hanging tight.
I certainly won't after what happened today, Judge. So
maybe you can give him a call or send him a text.
I will. I have his number.
Perfect. Thank you. All right. Ms. Cerda.
Good morning, Your Honor.
Good morning.
I have CL 20-1570H on behalf of defendant Eugenio Sanchez. Ms. Cerda. It is number 14 on your civil docket, Your Honor.
Number 14?
Yes, number 14, Your Honor.
Yes, so Mr. Garza announced ready for trial. My understanding is you all are set for mediation on Friday.
Yes, Your Honor.
And we're set for docket call on the 27th at 1:30.
Yes, Your Honor. Very well.
So is there any, do you anticipate any issues, or you all are announcing ready for trial subject to the mediation?
Your Honor, we are announcing ready for trial subject to the mediation. So hopefully we can settle, but if not, we're announcing the same.
Perfect. We'll see you on the 27th at 1:30 then, docket call.
Thank you so much, Your Honor. Bye-bye.
Thank you. Mr. Davis, what do you have?
Good morning, Judge. It's on cause number F0620-21-8. I represent Mr. David Garcia in that case.
All right, Ms.
Good morning, Your Honor.
I'm sorry, Ms. is on the other side.
Good morning, Your Honor. Melinda Diaz. I represent Amanda Garcia.
All right, I have a
I have a motion, Judge, regarding the child support that actually we had filed back in June, and for different reasons, it got passed a couple of times. So that's before the court, and I believe Ms. Diaz also has a motion that's before the court.
Okay, you guys, I'll listen to you all and tell me what you think will be the most efficient way, whose motion to take first, and how to go about this. Who wants to go first?
Well, I think ours would, Judge. And initially, we had come before Your Honor, and we had reached an agreement regarding child support based upon my client's wages at the time. He was employed with the Mission Police Department. Subsequent to that, in June, he was terminated by the police department. So we filed the motion to adjust his child support based upon his present wages, which at the time and continue to be zero. He's not earning any income. And we're asking that it be effective July 1st of 2021. And I think in Ms. Diaz's motion, she is asking for the child support arrears to be deducted from my client's portion of the sales price of the marital residence, which is about to close or has closed.
Okay, Ms. Diaz?
Judge, I would agree that those are the arguments, Your Honor. I don't believe that it's that clear cut. As he just finished telling you, he got fired back in June of 2021. We're already January of 2022. I believe the testimony is going to show that he hasn't made any due diligence to try and get another job. He wants us to set child support at minimum wage, which is $7.25. And I will submit to the court based on his training, his education, and his experience, he should be able to get a job that would not require him, that would not prohibit him from getting a job that would pay more than that. In fact, you can go to Target right now, Judge, and get a job at a minimum for $15 an hour. And so I don't believe what they're asking is fair and just or in the children's best interest. Despite that, Your Honor, he's managed to maintain himself and his standard of living, having an apartment, but not paying the child support that he's supposed to. He hasn't paid any medical support, and medical support has nothing to do on how much money you're making, but rather what the actual cost is. He hasn't paid it. The court had already given him an adjustment, even when we went back to court during temporary orders and lowered it to $1,000, with the rest being paid once the house would be sold. The house has been sold. They're going to do closing this Friday, Your Honor, and we're asking for those proceeds to go towards child support since he has not aided the mom in trying to support these children.
All right, do y'all want to put on any testimonies?
We do, Your Honor.
All right, Mr. Davis, is your client present or?
Yes, I believe he's here on the screen. Mr. Garcia, can you?
Yes, sir, I'm here.
Okay.
Okay, and Ms. Diaz, who is your client?
Your Honor, my client is Ms. Garcia, and she is here present with me, Your Honor.
Okay, perfect.
Good morning.
All right, and Mr. Garcia, if I can have you turn on your screen, I suspect that Mr. Davis or Ms. Diaz will be asking you questions.
Yeah, there you. Can you see me now?
Yes, I can see you now. Thank you. Can I have both Mr. Garcia and Ms. Garcia, please raise your right hand. Do each of you sort of tell the truth, the whole truth, and nothing but the truth, so help you God? I'll start with Ms. Amanda Garcia. I didn't hear you, ma'am.
Yes, Your Honor.
Thank you. And Mr. David Garcia.
Yes, Your Honor.
Thank you. Ms. Diaz, since this is your motion, I'll allow you to ask questions of either your client or Mr. Garcia.
Yes, Your Honor. Mr. Garcia, are you currently employed?
No, ma'am.
How long has it been since you've been employed?
Since June of 2021.
And in June of 2021, how were you employed?
I was a police officer at the Mission Police Department.
And how long have you been a police officer?
17 years.
And why are you no longer employed with the McAllen Police? I'm sorry, with the police department?
I was terminated June 13th, 2021.
And what were the grounds of your termination?
They alleged multiple policy violations.
Okay, and what were those policy violations?
It was conduct unbecoming and numerous others.
When you say numerous others, what were the others?
I don't have them on hand with me, ma'am, but that was the main one.
Were there any criminal charges based pending against you?
Yes.
Okay, and what charges are those?
Driving while intoxicated.
So basically you were terminated for getting a DWI?
Yes, ma'am.
Okay, was that your first DWI, sir?
Excuse me?
Was that your first DWI?
Yes, ma'am.
You had never been arrested for DWI before?
No, ma'am, there's nothing on my record.
I didn't ask if there's anything on your record. I asked if you've been arrested for one before.
No, ma'am.
You understand that you're under oath, sir?
Yes, ma'am.
So you're telling this court that back in 2000, you weren't arrested before for DWI?
Well, those cases are exonerating expunged, ma'am.
But I didn't ask you that. I asked you if you've been arrested before. Not if they
Judge, I object to this. If he's had an expunction, he's under no requirement to disclose that in this court. This isn't a criminal case. He's not testifying in a criminal case.
And that's correct, Judge. He's not required to reveal it in a criminal case, but this is a civil case, a family law case that his child support depends on.
No,
And
he's only required to.
If I may finish. And it's going to show why he hasn't been able to get a job. If he's going to claim that these DWIs are keeping him, then it's relevant to this court. It's also going towards his intentional under or unemployed judge. If he continues to get the DWIs, those are intentional, Your Honor. And I think that the court should hear that history.
It's not on his record, so it's not preventing him from getting a job with regard to the DWI that's been expunged.
All right. It's clear that back in 2000, he got another DWI and that one got expunged by way of pretrial diversion. So it's not prohibiting him from getting any employment. It's something that is, you know,
On the printer.
I guess at this point, it goes both ways. I mean, it's relevant in the sense that it's informative for the court, but it's not something that's prohibiting him from getting a job, which I think is what Ms. Diaz is going towards.
That's correct, Your Honor.
Go ahead. I'll allow you to continue to ask questions.
Okay. Mr. Garcia, since you got fired in June of 2021, what efforts have you made to gain other employment?
I've been applying for numerous places. I applied even for unemployment, and they're also trying to help me gain employment. I had an interview last week, and hopefully I'll be hired by this Thursday at a warehouse.
Okay, let's go back since you said you've applied at various places. Back in June of 2021, where did you apply?
Nowhere, ma'am. Not at that point.
Okay, and back in July of 2021, where did you apply?
Nowhere, ma'am.
Okay. In August of 2021, where did you apply?
I had not, ma'am. I had been cleared to work on my doctor's.
Objection as to non-responsive, Your Honor.
When was the last time you applied, or when was the first time you applied for employment? Just so we can, because I don't want to go through October, November, December. I mean,
Right. Yeah. It was probably about the beginning of the end of October, early November, sir.
That's when you first applied for a job?
Yes, sir. I hadn't been cleared to work by my doctor, so I hadn't. But in spite of that, I've still been applying.
So when you were terminated by mission, you were under doctor's care?
Yes, sir. I was on family medical leave pending workman's comp.
For an accident or for what?
For an on-duty incident, yes, sir.
Okay. And so in October, you were cleared?
No, I have not been cleared yet.
Well, you have not been cleared?
No, sir. But in spite of that, I'm still looking for work. And just on top of that, sir, when I was arrested, I was carrying a firearm, my off-duty firearm, which I was required to do as per policy with my department. And I was charged with a weapons charge and lawful carrying of a handgun. But that was part of my policy. And it's also preventing me to work because it's kind of scaring off employers, sir.
Okay. Ms. Diaz?
Yes, you said you were on family medical leave. What was that for?
I was diagnosed with PTSD on duty.
And when were you diagnosed with PTSD?
Initially in November of 2021. I'm sorry, 2020, ma'am. Sorry.
So you were diagnosed with PTSD in 2020, but were you working in 2020 in November?
I was employed. I was
Okay.
employed still, yes.
Okay, but were you on actual duty?
I was on, at that point, I was on family medical leave.
So you weren't working?
I wasn't working actively, but I was still employed, yes.
Okay. So you weren't going to work back in December of 2020?
No,
You were staying home because you were you were on medical leave and you were still earning an income based on that release?
that's right.
Okay. I believe that your PTSD, what are you claiming caused your PTSD? What trauma did you sustain?
I was involved in an officer-involved shooting. I was the acting supervisor on the scene.
And when did that
friend?
Okay. And when did that shooting take place?
In June of 2019.
And were you claiming that your PTSD is what was causing you to what led you to get your DWI?
I'm not making that claim, ma'am.
Okay. So you haven't filed any kind of appeal or anything stating that based on your PTSD is why you were having these other alcohol problems?
An appeal to who specifically?
You're trying to get your job reinstated or your license reinstated, correct?
Yes, ma'am.
Okay, and so you appealed that where they removed you from it, correct?
With the job, yes, ma'am.
Okay, and so during that appeal, you claimed because of your PTSD, that's why it was not, they should reinstate you because you got that based on PTSD.
We're not quite there yet, ma'am, no.
Okay, when you say you're not quite there, what does that mean?
Well, because I still have the criminal case pending and really nothing can move forward until something comes of that.
Okay, and do you have a set date for your criminal hearing?
The next hearing is in October.
Now, the jobs that you said you started applying for back in October, what job did you apply for in November of 2021?
I've tried to keep up with the mandate with the unemployment, which is typically about three positions or 3 places per week. Just the numerous places, anywhere, warehouse worker, stocker, inventory, just certain places, Amazon.
Mr. Garcia, perhaps you didn't understand my question. I didn't ask how many, I asked where did you actually apply?
Oh, well, LNF, Glazer, Amazon.
Okay, okay. LNF is one of them. Is that LNF here in McAllen?
Yes, ma'am.
Okay, and what position did you apply for?
Multiple positions affected, warehouse worker, inventory, stocker.
Okay, and did you apply in person, online, or how did you apply?
Online. Every one has been online.
Yeah, okay. And when you applied, did you get a rejection letter?
No, ma'am.
Okay, then did you call back and see to hear back if you did or didn't get hired, if there was positions opening? What did you do in order to follow up and see if you were going to get hired at LNF?
I made multiple calls. I tried to make appointments with supervisors.
Okay, and who did you speak to at LNF to see if you were going to be getting that interview or not?
That one was a man named Diego. I don't have a last name for him though.
So you're telling this court that you have an application, but you've never received any type of letter, either rejecting it, declining it, or anything of that nature?
No, ma'am. Matter of fact, this rejection letters, I didn't even know they had those.
Okay, so everywhere that you've applied, you've never been actually told that you're not going to get the job. Is that correct?
Yes.
Okay.
Well, at
And-
LNF, they did tell me, but then I reapplied for other positions, so that's what I'm pending. I didn't get that one specific position back then.
Okay, and so you're still pending a job at LNF, according to you?
Yes, ma'am.
Okay, have you set up an interview?
I've been interviewed twice by them.
Okay, who interviewed you?
The same individual, Diego.
Diego what?
I don't have his last name, ma'am.
Okay, did you do an online, face-to-face, Zoom, telephone call? How did you get interviewed?
The interviews were in person.
And you went into the LNF company and actually had an in-person interview?
Yes, ma'am.
And when was this?
Oh, I don't have this. The last one was last week. I don't know when the other one would be.
And the one with last week was with Diego?
Yes, ma'am.
Okay. And did they tell you when they'd get back to letting you know if you did or did not get hired?
That they would try to get back to me by this Thursday, this week.
Okay. And what is that position?
That would be inventory.
Inventory. And what rate of pay would you be receiving if you got the job at LNF for inventory?
I believe it was at $12 an hour, ma'am.
Okay, where else besides LNF have you actually gone an interview after you applied?
That is the only one.
Okay, and all the other ones you just applied online and didn't hear back, only LNF?
Yes.
Okay, can you give me another one that you've applied in December for?
Glazer Distributing.
And what is Glazer Distributing?
It's another company similar to LNF. They distribute, Pepsis and beverages, so forth, and other items, food items.
Is that a local company?
It's in McAllen.
Kellen? And how did you apply with them? Was it also online?
Yes, ma'am.
Okay. Have you heard back from them?
No, ma'am.
Have you had an interview with them?
No, ma'am.
What efforts have you made to contact them to see if in fact you can get an interview?
Like they said in the application process, just to be checking emails and to be patient that they get back to us.
Okay. And this was back in December?
Yes,
Okay. So about a month has gone by, but you haven't checked back.
just check the emails.
Just check your email. And who's your contact person at Glacier?
I don't have a contact person.
So other than LNF and Glacier, where else have you made any effort to try and retain employment?
Amazon,
Okay, what position were you applying for at Amazon?
a driver, a flex driver, warehouse, inventory, has warehouse rep, I think is what it's called. Yeah.
Mr. Garcia, do you have experience or training in jobs having to do with warehouses?
A little bit.
Okay, what experience do you have?
Oh, many years ago, I worked at a warehouse.
Okay, what exactly does that job entail, the ones you've applied for?
Well, they're all different positions, but essentially it's everybody's kind of helping out with the warehouse, the intake, the outtake, the delivery, the stocking, and the scanning, stuff like that.
Inventory coming in, loading it
Inventory,
up.
coming in, going out, yeah.
Okay,
Deliveries.
have you applied anywhere else other than Amazon, Glacier, and at LNF?
I do. I don't have the records here offhand with me.
Have you applied anywhere where you, such as a Target or Walmart, where you're walking in and saying, we are hiring? Have you applied at those places where they have
At those
signs?
places, no.
If I may finish my question, at the places that actually show an advertisement and are actually advertising bonuses to go in and apply, have you done that?
These places I applied to, yeah, they did say those things.
Okay, have you applied at Target?
Not Target,
Okay, have you applied at a Walmart?
not a Walmart.
Okay, have you applied at any type of the food industry?
Pending application with a produce company. I'm not.
Okay,
finished
what
with the
produce
resume
company is that?
yet. Hang on, give me a moment here. Let me get it for you.
While you look for that, can you tell me how much the job at Amazon that you're still waiting on would be paying you, sir?
That one was listed at $15 an hour.
Okay, and the one at Glacier, sir?
That one, I believe, was also 12 an hour.
12 an hour, okay.
Yes, ma'am.
Sir, and all these applications that you've done online, you have copies of those applications?
No, ma'am.
Why wouldn't you have copies of the applications?
It's an online application, ma'am. It just, you submit it after you're done with it.
Okay, you email it, correct?
It sends you to a portal.
Okay, but all that is done online through email, correct?
No, you go on their website, then it sends you to a link, and then it's kind of like a portal. You apply and you submit to them. But
Okay,
they respond by email.
Okay, and so just so that I can make sure, so we'd ask you for copies of any applications, you're going to tell this court you don't have any. Would that be fair to say?
Yes, ma'am.
So you have, other than your word, you have no proof that you've actually applied.
I mean, I'm sure I could get copies if you needed them.
Well, that's what I asked you, if you would have copies.
I don't have copies. I probably could get copies.
Have you tried getting a copy of the applications that you've applied for?
No, ma'am.
You've made no effort.
Not for copies, ma'am, no.
Okay, you do realize that you were sent discovery where we were asking for those applications, correct?
I was not.
Okay, well, we sent you discovery and the discovery is due today. The 30 days would be up today. So you would have had to have at least already been trying and making efforts to produce what we asked you for. You're telling
When was
me
that?
so far. Well, I'm asking so far you haven't done that. Would that be fair to say?
That's right, ma'am. But when was that?
Asked and answered. I think we covered this.
Okay. So you have no knowledge of a request for production that was sent to you through your attorney?
For that, no, ma'am.
Other than your word here today, what were you expecting to show the judge of your due diligence in looking for a job?
My testimony that I've been applying, I'm actively looking, ma'am. Even though I haven't been cleared, I'm still actively looking for work.
Okay. So you have a retirement account, correct?
Yes, ma'am.
Do you know how much is in your retirement account?
Roughly about $83,000.
Okay. Do you have access to that account?
Yes.
Is there anything other than maybe penalties or a fine for you to be able to withdraw from that retirement account?
Yes, I'm leaving it in there because I'm trying to get my job back. So when I get back to it, it can still be there.
Okay, but that wasn't my question. My question is, are you aware of anything that would prevent you from getting it other than any fines or penalties you might be charged?
I haven't actively looked into it, not that I'm aware of though.
Okay. Have you ever withdrawn from your retirement account?
No, ma'am.
Have you ever borrowed against it?
No, ma'am.
Okay. Mr. Garcia, where do you currently live?
Here in Edinburgh,
Okay, are you living in a home, an apartment with family members? Where do you live?
in an apartment.
Okay, and how much is your monthly rent?
$1,090.
Okay, sir. And who is paying the $1,090 a month for you?
I'm getting a lot of help from my family, ma'am.
Okay, which family member is helping you specifically?
My mom, my dad, my brother.
When you say your mom, is this the same? Isn't your mom putting her house up for sale?
Yes, ma'am.
Okay, and she herself is moving into an apartment?
Yes, ma'am.
Okay, is your mom retired?
Yes, ma'am.
What is she retired from?
Oh, she had numerous jobs, ma'am. She's getting a VA pension, Social Security, and other funds.
Okay. Is your father employed?
No, he's retired.
He's also retired. And I understand that your father's currently ill?
Yes,
Okay, in fact, I believe he was in the hospital?
he's still under medical care. Yes,
Okay.
he's in an assisted living facility right now.
And is this one of the family members that's helping you financially?
Yes, ma'am.
Your dad?
Yes.
Okay. And you said a brother. Which brother's helping you financially?
I'm my brother Albert.
Okay. And when you say they help you financially, how much money a month does your mother give you?
I don't know. She's helping me with whatever I need as I'm looking for a job and going through this process, man. I don't have
Okay.
a definite number for you.
Do you know what your mother's monthly income is?
I do not.
Okay. But you know that it's enough to help you pay $1,090 a month for your apartment?
She does well for herself, man.
Okay. And how much does your brother Albert contribute to you financially?
I don't have a set amount, man. Whatever, I've asked of him. He's been very generous with me.
Okay. And other than your rental for $1,090, what other monthly expenses do you have, sir?
I've got a truck payment and utilities. That's it.
Okay. And how much is your truck payment, sir?
It's $560 a month.
And you said just utilities there at the apartment, sir?
Yes.
Okay. And how much are utilities?
Water's probably about $40 and light maybe $70.
Okay. So, okay. Roughly $110.
Roughly.
Okay. Sir, do you have a cell phone?
I do.
And who pays for that?
My mom's been paying for it.
And how much is a cell phone?
Oh, I think $60 a month.
Okay. Do you have health insurance, sir?
No, not anymore.
Okay. Are you providing health insurance for your children?
No, ma'am. No.
Okay. And how much child support are you paying a month?
Excuse me?
How much child support are you paying a month?
300.
And are those also funds that come from family members?
Yeah.
Okay. And of course, this isn't including gas or groceries, correct?
Right.
Okay, so you're, just so I can make sure you're 100% relying on family members for your financial support.
Yes, ma'am.
Okay.
They don't have any income coming in.
Okay. Mr. Garcia, how did you select this particular apartment where you're paying $1,090?
I wanted something closer to the kids, something nearby to their schools as well.
Okay. And this is the only apartment that you could find?
I know there were numerous others, but as far as pricing and so forth, they're pretty much the same, but this was the one in a good area for them.
You talked about that you didn't mention any cable. Do you have cable at your apartment, sir?
No, ma'am, I don't.
Okay. Do you have internet?
I do have internet.
Okay. Who pays for the internet?
Like I said, I get help from the family. I don't specifically tell them I need for this or that. I just.
Okay. And how much is your internet bill a month?
I believe it's $60.
Okay. In addition to all the other ones that you've given me, correct?
Yes. And I mean, I have borrowed money, ma'am, because my house is pending sale. So this is why they're being, I guess, so generous, because it's going to be paid back.
Okay, let me go back a little bit then. Who did you borrow money from? From a loan institution, or are you talking about the family members?
No, I'm talking about my family.
Okay, so if you're telling me you don't know how much money they lend you, how do you know how much money to pay them back?
Because my mother's not keeping count of what she's giving me is why I don't have a set amount, but she's helping with whatever I need.
Okay, and to pay this money back if you're not keeping an accounting?
Excuse me? You got cut off.
How do you know what to pay them back if you're not keeping an accounting?
Well, because of what my mom gives me, I do kind of keep track of. What my brother gives me, I do keep track of differently. But my mom says I don't have to pay her back. But
I understand. You just finished telling me that you keep it. And I asked you earlier, how much does your mom give you? And you said you didn't know. So either you're keeping an accounting or you're not. Which is it?
Well, roughly I do of what she gives me, but she doesn't want me to pay it back. So it's not really like I'm keeping track of it.
I understand that, Mr. Garcia, but I'm not asking if you're paying it back when I asked you, how much does your mom give you? And you said you did not know. Now you're saying you keep an accounting. Which is it?
I don't have a number for you, ma'am.
Okay, so then you don't know what to pay her back.
Right.
Okay, and you don't keep an accounting of how much your brother pays you?
Yes.
Okay, and how much does your brother pay you a month? Because earlier you told me you didn't know.
Well, he doesn't give me anything per month. It's if I go and I ask him for something.
Okay, and what have you asked him for since you got laid off that you need to pay back?
$2,000.
And when did he give you that $2,000?
Sometime late last year. I did borrow money from another friend of mine as well that I do keep track of.
Okay, who's that friend that you borrowed money from?
His name is Enrique.
Enrique what?
Lopez.
And what does Mr. Lopez do for a living?
He's a police officer.
Okay, and what is Mr. Enrique Lopez's phone number?
Let's see.
And while you look for that, tell me how much money you borrowed from him.
I borrowed $5,000 so far from him.
Okay, you said so far. Is it in installments? Was it one lump sum, or how is he giving you $5,000?
He's giving me the $5,000 up to this date, and I haven't asked him for any more. I have his number when you're ready.
I'm ready.
956 458 3806.
Okay. So anybody else that you keep an accounting for that you borrowed money from?
No, ma'am.
Okay. Now, in the list that you gave me, where in that list is the mortgage for your home that y'all are putting up for sale? Who's been paying for the mortgage?
I got on a program to hold off payments.
Okay.
I have proof of that for the past few months. So I hadn't had to pay it.
When did you apply for the program, sir?
That I don't have. I can get that, but I don't have it.
So
Right.
was it last month, last year when you got laid off?
No,
When
it was last year after I got terminated.
Okay, so, and have they been installing the payments? What did they do exactly to keep you from having to pay the mortgage? Did they defer it?
It's like a hardship case I had to apply for. Being the situation is what it was. And I mentioned to them, I'm going to sell, but, I wouldn't be able to pay going forward. So it's like on a halt right now.
So you haven't made any monthly payments on the mortgage since June of last year?
Yes, ma'am. That's correct.
No payments?
No.
Okay, and so now, and your house is up for sale, correct? In fact, you have a buyer.
Yes, ma'am.
And you're doing a closing this coming Friday?
Hopefully, ma'am.
Okay, and as far as you know, your realtor is Dalia Lizondo, correct?
Yes.
And you went over the numbers with Dalia?
Yes.
And did Dalia tell you how much money you were going to be receiving?
Yeah, she sent us an email.
Okay, and how much is it that you're receiving?
It's roughly about each of us about 48,000.
Okay, and out of that 48,000, does it already include the payment back for all these months that you haven't paid on the home?
Yeah, it was just put on hold. It's not like I have to repay that. It's just put on hold.
Okay, wait. I'm a little confused. What do you mean it's not like if you have to repay it?
Like, in other words, it's not going to eat into the profit of the sale of the house.
So who's paying for those months that you didn't pay that it was on halt?
Nobody's paying for it. Like the ending balance of what's owed is going to be paid. And we have a lot of equity in the home. So it's going to get paid off.
So that's what I was asking. It already includes that amount. In other words, whatever you owed,
yes.
They tacked it on, and now you owe a bigger chunk because all those months it wasn't paid.
No, I still owe the same amount. If I were to keep the house, then they would tack it on, is what the way they explained it to me.
Oh, okay.
Like the money's due, yes, anyway, which is going toward the mortgage amount, the bottom line of what is owed on the house, finance.
How much were you paying monthly, sir, before it got halted?
Let me see. 16. I want to give you the exact amount here. 1716.43.
Okay, so, and how many months was it halted for?
I don't have that with me now.
Well, sir, you applied for it. When did you apply that they started halting?
I don't have that with me now. I can get that for you, but I don't have that here in front of me.
Well, let me ask you this. Did you make a payment in June of last year?
Maybe not. Maybe it was already halted at that point.
You're not sure.
Right.
Did you apply for this hardship before or after you were laid off?
I believe it was before because I was anticipating it.
Okay. And before, when you applied for it, did it require your wife's signature?
No.
Okay. So did you give your wife, Amanda Garcia, notice that you were applying for this halt of this payment?
No.
Okay. Did you ever make her aware that for the approximately 10 months you were not paying the mortgage, that it was being halted?
No.
Okay. And when you did the closing, was she made aware that part of the mortgage, part of the, it was including these halted payments, in other words.
What do you ask?
In other words, they had to have tacked on approximately $10,298 to the debt because of all the months you had not paid. If you take 1,716 and you multiply it, that would about be the amount by 6 months that you didn't pay.
Ms.
So it would be,
Ms. Diaz, isn't this a community debt?
yes, it is, Your Honor, but what I'm trying to tell the court, we're asking this court for her to be paid for child support from the funds of the sale of the house. If those,
I have no problem with that. I think we should just move on because we're just.
I understand, but the amount that's going to be paid will make a difference, Your Honor, because during the temporary orders, he was supposed to be paying for the mortgage. And if they're now tacking it on to her, we need to
But
do
it's a
that.
community debt. It's a community debt, so he's going to get reimbursed for that. Why should he pay 100% of the mortgage and not get reimbursed for that?
Because, Your Honor, you ordered it in temporary orders because he had the benefit and use of the home. So you said he was responsible for the mortgage payments. That's why.
Okay, so
I was working with her.
She was
I'm
not
sorry,
in the
sir?
home. She was not in the home.
No, she was not.
Oh, okay.
He had exclusive use of the residence, Judge, and part of him having exclusive use, which he requested, he wanted to stay in the home. So my client had to move out with the children. So the court ordered him to be paying for the home.
Perfect. Okay. Why wasn't this? I mean, I see that this went to mediation and it wasn't, there was nothing that, why couldn't you all resolve that, Mr. Davis? Why couldn't that?
Judge, you know why we couldn't resolve it in mediation? Because
Judge, I'm going to object to anything in mediation that's against the rules, Your Honor.
Correct. I'm just, look, we're taking up, I have Mr. Ortiz, I have all these people, and we're asking questions that are really, in my opinion, look, we're going to deduct however much she's owed in child support from the proceeds of the sale. Is there anything else I need to go over? Is there anything else I need to decide?
Judge, well, what the child support should be, because we filed the modification back in June, but they want the child support to stay as it is and deduct that, and we're saying it should be the $300 per month. Because that's what it comes out to.
Right.
It's not working.
Correct. Okay, so you're wanting to go back and make it from the day that you filed the motion to modify the child support based on.
From July 1st.
And you filed your motion to modify at that time on July 1st?
We filed it in the month of June, Judge.
Okay. All right. And so your claim is he's been unemployed since then, and you want to make it as based on minimum wage?
Yes, sir.
Okay. Is there anything else?
That's all I have before the court. I mean, I could take my client if you want to hear some cross-examination, but I think Ms. Diaz has elicited all the basic facts.
Yeah, I mean, I think the basic facts are what they are, and I think that she should get reimbursed from the sale. And I think that needs to be decided here today before the sale is finished on Friday. It's pretty simple. I don't.
Your Honor, I agree with the court, but the amount that the court is going to order is very relevant here. And I believe the information that we've been eliciting goes towards his due diligence of trying to get another job if he's intentionally unemployed, Your Honor. And I mean, he's already testified that for the first 4 or 5 months, he wasn't even attempting to apply. And then he tells us he has no proof of any applications or anything. We already called Mr. Lopez, who has already told us he never borrowed any money from him, Your Honor. I mean,
I object to that. That's not evidence.
So,
I think we need to put my client on.
Mr. Lopez did not give 5,000 as Mr. Garcia testified to?
Not from the phone call we just made.
He did, Judge.
You want to get Mr. Lopez on the line, Ms. Diaz?
Get him on the line.
Give him the Zoom link.
That's what we were trying to do. My client had stepped out and trying to get him into the Zoom, Your Honor, because that's what he told her. I'm trying to see if we can get him on. Get him.
Let me pause this hearing. Let me try to get you on. You have the Zoom link. Pass it on to him. Let's get him on. Let me handle Mr. Tijerina and Mr. Medina real quick because I know that they're both back on and this should be quick.
Yes, Your Honor.
Hang tight. Okay, Mr. Memo and Mr. Medina.
And I,
Good morning, Your Honor.
Give me, wait, this is CL 193702H, Ruben Duran versus Dorothy Gott.
Morning, Your Honor. Raul Medina for the plaintiff, Ruben Duran.
And Memo Tijerina here for Mrs. Gott, Your Honor.
All right, Mr. Medina previously announced ready for trial that is set for the 31st of January, docket call on the 27th. And Mr. Tijerina, I have a note here that you are asking for reconsideration on an order granting plaintiffs traditional motion for partial summary judgment.
That's it, Your Honor. We're also ready, Judge.
Okay, so you're ready for trial,
Yes.
and I guess we could take up the reconsideration.
The reconsideration, Your Honor, I'll be pretty brief. I filed this before. If you'll remember, Mr. Medina filed the summary judgment relating to liability after my client had responded to admissions. And when we had the argument, I had argued, and it's in my prior motion, that it was premature because I hadn't had an opportunity to take the deposition of Mr. Duran, see what, if anything, he could have done to avoid the accident or whether he contributed to cause the accident. Since that time, we took Mr. Duran's deposition. This accident, Your Honor, occurred as my client pulled out from a stop sign, and Mr. Duran was in the lane of travel. I filed the deposition excerpt, Your Honor, because in this case, we believe that there's a fact question as to whether Mr. Duran could have done something more to avoid an accident other than just kind of seeing somebody making a mistake, pulling out from a stop sign and then having the accident. And the testimony, and I'm looking at a different screen, Your Honor. I apologize. I'm working out of the house. My wife got COVID yesterday, so I can't go to the office. So I'm looking at a different kind of laptop that's connected to my office. And it says, when Mrs. Gott, and then Mrs. Gott, where was she when you saw her when she was turning? Well, the thing, I saw her, I got peripheral of her traveling here on this road straight. So I saw her, I kept looking to see where she was going to do. And I could see that her attention was here. She never saw me. So when I saw her engage the turn, I started honking, and that's when she just came and hit me right here. Okay, Mr. Duran, I understand that kind of as you were driving, you were able to see Mrs. Gott's truck, yes. And then you were able to notice that she wasn't even looking in your direction. She was looking at the Sioux intersection. Answer, yes. Did she ever turn to your direction? No. I think you mentioned in your statement, you started honking, yes. Can you give me an estimate as to how far you were from her? I mean, this is maybe 10, 20 yards, I mean, I'm just trying to gauge back to where I was. I mean, I could see her. I see her engaging. She's looking forward. She's not stopping. And I'm start honking because obviously if I would have had the opportunity to be able to stop and avoid her hitting me, I would have done it. But I was, and again, I'm not a police officer. I'm not. But, I had the right of way and she just came out of nowhere. And so, Your Honor, and this kind of goes back to when this came up previously. Under Texas law, everybody has an obligation to avoid an accident if they can. If you see an adult jaywalking somewhere that they're not supposed to be, and you see that they're not supposed to be there, I mean, you obviously, if you can avoid the accident, you need to avoid the accident. And here, Your Honor, it's a fact issue as to whether a jury could believe that Mr. Duran contributed to cause this accident when he didn't do something different, when he saw very clearly that my client was never even looking in his direction, because it would appear, Your Honor, that she thought it was a one-way. Okay, I mean, that's not before the court, but I mean, just by way of context. And so for that reason, Judge, we just as we did previously, we think that, a jury should be entitled to hear and consider Mr. Duran's actions, because if there's any evidence that would support the agreement that he could have avoided this accident, then we think we're entitled to hear a jury consider that. And I apologize for the noise in the background, Judge. I just heard my boys come inside. Boys, be quiet, please. This has been a challenging 24 hours, Judge.
It's been challenging 2 years.
Yes. Okay, and that's my argument, Judge. I'll let Mr. Medina respond.
Mr. Medina.
Yes, Your Honor. Nice buck, by the way, Memo. Congrats on it. First of all, Judge, there was no stop sign. Basically, the defendant was traveling, just for context, was traveling in a closed construction area and then tried to get into the lane my client was traveling on. But most importantly, Judge, when we filed our plaintiff's motion for a partial summary judgment, I included 2 exhibits into evidence. Exhibit number 1 is the defendant's clear admission that she was responsible for causing the accident, okay? She didn't take partial responsibility. She didn't say, well, Mr. Duran should have done X, should have done Y. And I also included the accident report that clearly places her at fault. That was the evidence before the court. The plaintiffs met their burden to show that there was no genuine issue of material fact and we're entitled to judgment as a matter of law. And that's what the court ruled, and that's why the court granted our order going on 2 years from now. Now on the eve of trial, now they try to point fingers to the plaintiff, who is completely innocent here. Even the defendant herself says, I take responsibility for causing this accident. Now, if that would have been an issue, then he should have followed up with an affidavit or something indicating that, oh, the plaintiff is also partially responsible for causing this accident. Then I would have taken a deposition and then we would have cleared that matter up, Judge. But what was before the court was the evidence, which was her plain admission that she is responsible for causing the accident. Now, this partial summary judgment goes to liability. In other words, duty and breach of duty only. We still have the issues of causation and damages that we're going to address with the jury. Now, I asked this court to deny the motion because, one, it's going to increase the length of the trial. And then now I'm going to have to take a deposition of the defendant because she's clearly admitted, but now, opposing counsel, wants to argue that he could have done something to avoid it, and he did, he honked. But obviously she wasn't following traffic laws and she tried to merge and the impact happened. But more clearly, Judge, she already accepted responsibility. The State Farm and the defense wants to bring this little old lady into trial. So, there could be a sympathy factor, but there's no issue as to duty and breach of duty. She accepted responsibility for causing this accident. So on those bases, Judge, I ask this court to deny their motion to reconsider.
All right, Mr. Tianina, anything to add?
Just very briefly, Judge, I would note that this has been in our answer, the proportionate responsibility, the failure to keep a lookout. Your Honor, nothing about what my client would talk about at her deposition would relate to Mr. Duran and what he perceived in the truck and what he could or could not have done. And Your Honor, the fact that my client says, hey, look, no question, I have some responsibility for this accident, that does not exclude, okay, Mr. Duran's action. So it's not mutually exclusive. And Your Honor, I would just note that if there's any fact issue, a scintilla of evidence, a verdict won't hold up, Your Honor, if the defendant's wasn't allowed to put on a defense when there was a fact issue. And so, I think that would be a major delay, is having to come back down here because of an alleged defense that was pleaded in an answer, and then given Mr. Duran's sworn deposition testimony.
Real quick, Your Honor, if I may.
Go ahead.
First of all, if the court just reviews her admission, I think that'll just expedite this and the court can just deny his motion. The admission doesn't say that she accepts some responsibility. She doesn't qualify it. She takes full responsibility for it. That they want to make it a fact issue for a longer trial and, potential sympathy factor of the defendant. I get that strategy, Judge, but at the end of the day, we met our burden. There is no genuine issue of material fact. We have her admission in her admissions, and we're entitled to summary judgment as a matter of law. And that's what the judge granted. There's nothing new here to indicate that she didn't have a duty and she breached her duty and she accepted full responsibility. So we ask the court to deny the motion to reconsider.
The court's going to go ahead at this time, and obviously the court has already heard the evidence 2 years ago in February of 2020. The court is of the opinion that the motion to reconsider should be denied. You all are number one on trial docket call for the 27th and trial on the 31st. Both have announced ready. You all are the only show in town. We will be notifying, I guess, Judge Gonzalez, who is requesting that we notify him as a presiding judge of our intent to have a jury trial, and then we'll be notifying our clerks to get a jury panel. They've already been requested according to Eddie.
Thank you, Judge.
We'll see you all on the 27th, and if you all do enter into some negotiations and this case does settle, please do us a huge favor and let us know as soon as possible, because it's not so much that we have, there's so many involving moving parts in getting jury trials back up. It's not as simple as it was 2 years ago.
Right.
I'm making accommodations for where we're going to put the jurors, and even jury panels, things of that sort. It would really help other courts if you all would just give us that notice. If it
Yes,
doesn't,
sir.
no problem. But you all are number one, so you all are.
All right.
You're the only one for that week with us. Okay.
Excellent. Thank you,
All right,
Judge.
Judge.
All right. Thank you, guys.
Thank you.
Yeah, Memo. Good luck. Hope everything turns out well. Hope your family stays safe, and let us know if you need something. If you need us to make accommodations for you in the future, let us know.
We'll be great, Judge. Thank you.
Thank you. Okay, Mr. Ortiz, I know you have something and you've been patiently waiting. This is
Thank you, Your Honor. Good morning.
Good morning. CL 20-3612H, Open Road Enterprises doing business as El Jinete Drive-Through versus Jesus Paredes and Pueblo Tires LTD. Is there an opposing counsel on this case?
Not that I know of, Your Honor.
Linda Maloney?
Yes, Your Honor.
Okay. And you are here on behalf of Jesus Paredes and Pueblo Tires LTD?
Yes, Your Honor.
Okay. And this is a motion for summary judgment. Defendants, no evidence motion for summary judgment and motion to dismiss for want of prosecution. I have a note here that arguments were heard on 12/6. I'll be honest and say I don't remember, but that was about a month ago.
That's okay. We filed a reply to defend or plaintiff's response to our summary judgment, setting forth a number of objections because their evidence that they attached to their response, none of it was proved up or admissible. And the court asked me, if you sustain our objections, then we're entitled to summary judgment as a matter of law, and the court postponed its ruling because it needed time to consider the objections. Did that?
Mr. Ortiz didn't show up and he had an associate show up.
Correct.
Correct, Your Honor.
Now I remember. All right. Thank you for jogging my memory.
That's okay. And so you froze all of the evidence and the responses, replies, and the summary judgment to rule on them today. And so that's where we're at.
All right, Mr. Ortiz.
Your Honor, I've never received a reply to my response to her summary judgment, but it's really, the issue is moot. If her complaint in the earlier hearing was that the emails that I attached to my response were not valid for some reason. I've never had anyone attack me as an officer of the court or attack emails that I submitted in response to summary judgment. As the court knows, summary judgments are looked at the in the most favorable light as to the non-movement, which would be us, the plaintiff. I've never had a lawyer file a summary judgment for want of prosecution, and that is completely incorrect. I mean, I'll be happy to it's not be a long argument. The argument is that, of course, I've prosecuted this case. Miss Maloney, who I don't even see, I thought you had a rule that everybody had to show their face, but regardless, the response to summary judgment is, of course, a prosecutor did. This is filed in 2020. I've dealt with another lawyer in her firm named Craig Choate. It was very nice, very favorable. We reached an agreement. Their client has paid a part of the damages. We're asking for another part of damages. And I'm dealing with him, send him discoveries, or rather send him information. Without the need of formal discovery, we have been negotiating this case. Mr. Choate either got sick or got fired, or I mean, he's no longer with the firm. And Ms. Maloney took over, and I've had nothing but problems with her in getting information or getting a counteroffer. There has been a settlement demand, which is not a whole lot. This is property damage only, of about $45,000, $50,000. And I got an offer of $900. So that's where we're at. But to say that I haven't prosecuted the claim is entirely wrong.
Your Honor, response.
Go ahead.
We're going down a rabbit trail here because that is not the issue today, settlement negotiations, and they're also not admissible with regard to the issue before the court. The issue before the court is two parts. One, it's a summary judgment. And the second motion that was filed was a motion to dismiss for want of prosecution. So please do not, I respectfully disagree with opposing counsel and he's not reading the motions correctly. First, as to the motion for summary judgment, when a party files a motion, a no evidence summary judgment, as you know, we bring forth the portions of the elements for their cause of action that they have no evidence on. That is what we did. Plaintiffs filed a response attaching documents that are not proved up, which is, as a matter of law, no response. We filed an objection to same. Settlement negotiations are not summary judgment evidence. They have nothing to do with it. Plaintiffs have a duty under law to prove their damages. They have not done so. Giving us an offer is not a proof of damages. I have for months since I took over this case from Craig, who is no longer with our firm, asked for documentation supporting their damages, and I get emails. I don't get any hard documents. I don't get an affidavit. I get nothing. I just get these emails back and forth with the values. And I've told him repeatedly, you have to prove your damages. And he has not done so. In his reply, there is no evidence as a matter of law in Texas to support his response because none of it is proved up. And therefore it fails as a matter of law. Without that, we are entitled to summary judgment as a matter of law. On the issue of the motion to dismiss, plaintiffs have a responsibility to work up their case. This firm has not done so. Periodic requests for settlement is not working up your case. They've not taken depositions. They have not served discovery. They've done nothing for, we're in 2022. This is 2 years. They've done nothing. And so for those reasons, Your Honor, we're entitled to summary judgment. If not only if the court sustains my objections, but we're entitled to summary judgment because there is no evidence of the elements set forth in our summary judgment. Thank you.
All right, Mr. Ortiz, response?
Your Honor, as the court well knows, this is summary judgment. I just need to show a scintilla of evidence that we have, first of all, prosecuting the claim. If you look at my response, there are numerous emails and they're actually copies of damage, rather receipts of damages to my client's building. This is property damage only. It's El Jinete drive-through in Edinburgh. I think a lot of people in Edinburgh know this place. It's a beverage drive-through, and Ms. Maloney's client ran into the building. So it's property damage only. But if you look at my response, I have clearly sent photographs. I've sent receipts of damages. And so everything is there, but I have not dealt with her. I've dealt with a guy named Craig Choate. That's correct. There has been no depositions. This is a small case. There was no need to go through depositions or formal discovery. We were on the verge of settling this case when he disappeared. And so, but to say that I've not prosecuted the claim is absolute ludicrous. To say that I have no evidence, again, I've provided the court, this is a summary judgment. We don't even have a trial setting. So, we haven't gone to mediation. So, I mean, that's the extent of it.
Response, Your Honor.
Yes, go ahead.
As a matter of law in Texas, attaching documents that are not proved up to a response to summary judgment fails as a matter of law. That has never changed. That has always been the law. And nothing he has attached to his response is proved up. Therefore, the objection should be sustained and the summary judgment granted as a matter of law. Furthermore, just as a side note, the damages we're arguing over are not these alleged receipts that he has sent me. It is what is above and beyond business loss profits, which he is claiming up to $40,000. But I have not one shred of evidence, not one document, anything showing lost business profits. And that is why we are where we are, because the last 9 months, this firm has failed to provide me not one shred of evidence supporting business loss profits. Thank you, Your Honor.
Thank you. All right, let me take up the issue of the motion to dismiss for want of prosecution. That motion, I'll tell you right now, will be denied. My staff just printed out the responses. Mr. Ortiz, you saying you don't have her response?
I don't have her reply to my response to the summary judgment, correct?
Okay.
Your Honor, it was served electronically through the e-filing service. We have proof of service.
Let me review it, Mr. Ortiz, if you want. It'll take me about a couple of, give me 2 weeks to review it, and I'll have a decision. And then I've already decided on the wanted prosecution, the motion to dismiss, that'll be denied, but let's go forward on the summary judgment. And if you want to, I would encourage you, Mr. Ortiz, to contact the clerk's office and get a copy. And if you have anything you'd like to add in the next week or two, please do so. And then
I'll do so, Your Honor. I appreciate it.
Let me set this up for a, well, I'll do a, you'll have a decision by the, let's see, I'm going to be out the 19th through the 24th. Give me to the 27th.
Your Honor.
Of January, Your Honor?
Of January.
Thank you.
What date was that, Your Honor? I'm sorry.
It's not something that you have to show up for, Ms. Maloney. Okay. It's just, I'm giving myself a deadline to I have to, if I don't give myself deadlines and my staff doesn't stay on top of me to try to have me issue rulings. So it's okay. It's just a deadline to be kind of looking out for a decision by that day.
And what date is that, Your Honor?
The 27th, since I will be out I'll be out the 9th, 18th through the 20th, more or less.
And Your Honor, could you cut out a little bit earlier when you were talking to opposing counsel regarding if they wanted to submit what?
Well, he said he didn't receive your response to his, I guess he never received your correspondence. So I encouraged him to call the clerk's office and get a copy.
Okay, and we'll be glad to reserve it again and set him and the court proof of service. That's not a problem, but even without a reply, his response fails as a matter of law because, again, none of the evidence is proved up and he's missed his deadline.
All right, I will give Mr. Ortiz an opportunity to review that, your arguments. And then if he wants to fill up the court with, with any additional responses, he's free to do so. It'll give me some time. Again, the 20, did I say the 27th?
Yes, Your Honor.
Yes, Your Honor.
27th, please.
Thank you.
May we be dismissed?
You're excused.
Thank you.
Thank you. Okay, do I have anyone else besides Ms. Diaz and Mr. I see several, like I have Davina Duran. Ms. Duran, what case are you here on? And you're on mute, or at least I cannot hear you.
Me?
No, Ms. Duran, Davina.
Or another Duran? Okay,
Yeah,
sorry.
there's another Duran. Miss, still nothing, can't hear you. Ms. Yolanda Duran, while I have the other Duran try to get in contact, get her. Ms. Yolanda Duran, you're here on CL 202994H Midland Credit Management, Inc. versus Yolanda Duran, is that correct? And
Yes.
this case is set for a dismissal for want of prosecution. Is anyone here on behalf of Midland Credit Management, Inc.? Anyone here on behalf of Midland Credit Management, Inc.? Notice was sent to all parties. No appearance was made on the we had this case set for default hearing on 11/8, and we set it up for a DWAP today. This case will be dismissed for want of prosecution. Ms. Duran, this case will be dismissed for want of prosecution. It's typical, I will tell you that it's typical that they'll ask for me to reconsider once they get notice that we've dismissed it, and they've got an uphill battle at that point. So just, if you hear something from our court, please respond to it, but otherwise at this point, this case has been dismissed.
Yes, because I think we had court on December the 2nd and they didn't appear either.
Yes, ma'am. So the cases, as far
Or
as I'm
December
concerned,
the 1st.
as far as I'm concerned, this case at this time is being dismissed. They do still have some available remedies. So in case you get a notice from our court, please be mindful of that, okay?
All right, thank you.
All right, you're dismissed.
Thank you. Have a good day, sir.
You too. And Davina Duran is a divorce. I'm trying to see if she can get her audio back up. And then I have a Perla. Perla, what case are you here on? Number 8, a divorce as well?
Perla Longoria.
Yes, ma'am.
Si puede ser en español, por favor.
Okay, yes, ma'am. All right, Ms. Longoria, can I have you raise your right hand?
Si puede levantar su mano derecha, por favor, Ms. Longoria.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
¿Puede que testimonio que ahora esta mañana será la verdad y solamente la verdad?
Sí.
Yes.
Full correct name, Perla Longoria?
¿Es su nombre correcto, Perla Longoria?
Sí, Perla Macarena Longoria.
¿Perla qué?
Macarena Longoria.
Perla Macarena Longoria.
All right, Ms. Longoria, prior to filing the petition for divorce, had you lived in the state of Texas for 6 months?
Antes de que archivara este divorcio, vivió en el estado de Texas por 6 meses.
Sí.
Yes.
And in the county of Hidalgo for 90 days?
¿Y en el condado de Hidalgo por 90 días?
Sí.
Yes.
During the course of your marriage with Mr. Guadalupe Morales, were any children born or adopted?
Durante su matrimonio con Guadalupe Morales, ¿hubo niños que nacieron o adoptados?
No.
No.
Are you expecting any children at this time?
¿Y el momento usted está embarazada?
No.
No.
Was any community property acquired during the course of your marriage?
¿Obtuvieron propiedad de la comunidad durante su matrimonio?
No.
No.
And has your marriage to Mr. Morales become insupportable?
¿Y su matrimonio con el señor Morales se considera insoportable por conflictos de personalidades?
Digamos que nada más no concordábamos en cosas.
So we say that we just would not agree on things.
Okay, and you're asking the court to grant you a divorce?
¿Le está pidiendo a la corte que le dé el divorcio?
Sí, por favor.
Yes, please.
All right, and you got an opportunity to submit a final decree of divorce to the court, is that correct?
Y usted tuvo la oportunidad de archivar un decreto final con la corte, ¿correcto?
Sí.
Yes.
And your signature is on the last page, is that correct?
Y su firma está en esa última página, ¿correcto?
Sí.
Yes.
Do you have any questions about that final decree of divorce?
¿Tiene usted alguna pregunta tocante ese decreto final del divorcio?
No.
No.
And you're asking the court to sign off on it?
¿Y le está pidiendo a la corte que la firme?
Sí.
Yes.
The court's going to go ahead and grant the divorce along with all relief that's been read into the record. The court's going to take judicial notice of all documents in the court's file, including the waiver of service that was executed by Mr. Guadalupe Morales on November the 12th, 2021.
And
The
he-
final decree is granted.
La corte le va al divorcio así como la ha pedido.
Oh, Mr. Morales is present. I'm sorry.
Yes.
Okay, Mr. Morales, I apologize.
Señor Morales.
That's okay.
Mr. Morales, do you have any questions over this divorce?
No, I don't. I mean, it's the same as she said.
Okay. I noticed that you didn't have an opportunity or you did not sign off on the final decree of divorce. Had you taken a look at it?
Yes, I was out at work and we're not really fighting anything, so I have nothing against it.
Okay, and so you're also asking the court to sign off on the decree?
Yes.
All right. Court will go ahead and grant the divorce along with all relief. Thank you for logging on. I apologize for not seeing you there, but the court will go ahead and grant the divorce. And since you've had an opportunity to review it, both of y'all can get a certified copy from the clerk's office later this afternoon, okay?
Thank you.
You're welcome.
La Corte va a firmar el decreto, así como lo ha pedido, Ms. Perla. Puede tener una copia ya esta tarde.
Muy bien. Gracias.
Fine, thank you.
All right.
Es para retirar.
Both of y'all are excused. Okay, so that leaves us back with Ms. Diaz and Mr. Davis. Were you all able to locate the witness, Ms. Diaz? I don't know if she can hear me. Melinda, can you hear me?
I believe Ms. Duran fixed her audio as well.
Okay, Ms. Duran, can you hear me?
Yes.
All
Can
right.
you can
Yes,
hear me?
I can hear you.
Okay.
Let's go ahead and call F4196-218 in the matter of the marriage of Davina Duran and is it Janelle?
Janelle, yes. Yes.
All right.
Your Honor, my name is Davina Lamar Duran. I filed a suit for divorce from my spouse, Janelle Elizabeth Duran. At the time I filed for divorce, I've lived in Texas for at least 6 months and in Hidalgo County for at least 90 days. I'm asking for a divorce because our marriage has become unworkable. There is no reasonable expectation that we will get back together. My spouse and I do not have any children together. Neither my spouse nor I are currently expecting a child. I ask that the property and debts be divided as set out in the divorce decree. There's no property together. We are keeping our own retirement funds, 100% of our own. I have presented to the court. I believe that this division is fair for both me and my spouse. I respectfully ask the court to grant my divorce.
All right. Thank you, Mr. Dunn. But I should have asked you this before you started proving it up, but can I have you raise your right hand?
Yes.
Do you sort of tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Was everything that you just stated in your prove up true and correct?
Yes.
And you're asking the court to grant your divorce?
Yes, and there is an attached waiver of service that has been signed off by Janelle.
Court, and I've also noticed that she signed off on the final decree of divorce. Is that correct?
Yes, she has.
Court's going to go ahead and grant the divorce along with all relief that's been read into the record. I will have this signed off here momentarily. You should be able to get a certified copy this afternoon.
Okay, and then do I have to refile it with the court, or is that automatically because of this being Zoom? Do I have to actually, you'll file it?
Yes, yeah, no, we'll sign it. We'll send it to the clerk's office. You just need
Okay.
to contact with the clerk and get a certified copy.
You get a copy. And how long will it can be ready this afternoon? I don't need it.
Yeah, it should be.
Okay,
Yep.
perfect.
No problem.
I may be excused.
You're excused. Thank you.
Thank you.
Okay, Melinda, can you hear me? Melinda may have her audio off. Mr. Davis, can you send her a text or call her? Or maybe the office.
Okay.
Somebody can. Can you call Melinda?
Oh, yes.
I think she has her audio off. Melinda, can you hear me?
I can now, Judge. Thank
Okay.
you.
No problem. Okay, let's, we're back, and were you able to get a copy or that witness to log on?
Yes, sir. I tried to get him while I was on the line with him. Mr. Garcia called. He put me on hold. He came back and decided not to be cooperative and hung up on me. Okay, can you email me that information? I was speaking to Mr. Lopez, and then he says, hold on, and Mr. Garcia called him. He put me on hold. When he came back, he didn't want to talk to me anymore and hung up on me, so I wasn't able to give him any information. And I verified with him if it was Mr. Garcia on the other line, he said yes. And so I wasn't able to give him any Zoom information because he hung up on me after Mr. Garcia spoke to him.
Okay. All right. What other information do we need to get?
Go ahead, Dave. Okay.
I don't think there's any other information. I mean, the facts are pretty basic. He lost his job. He hasn't been making any income. He has made efforts to try to get a job, even though he's not been cleared to return to work by the psychiatrist he was seeing. You know, I don't really see the relevance. I mean, he just testified that on the question of how are you able to support yourself, his answer was because friends and family have lent me money. Are they saying that he has some job that he's not reporting, or I'm not really getting what the angle is here.
Judge, our angle is intentional underemployment or unemployed. First of all, he got fired, Judge, based on an intentional act, a crime. Criminal cases are intentional. He intentionally committed these crimes, so he's intentionally unemployed.
Well, Judge,
That's why he got fired. I did not interrupt him, Your Honor. I did not interrupt him, Your Honor.
Tim,
But you're misleading the court again, and
but Tim, I'll give you a chance to respond.
Okay.
Go ahead, Melanie.
In addition to, Judge, he's saying that he hasn't been cleared by a psychiatrist, and if the court will recall my line of questioning, he got that PTSD in 2020 and continued to work. He worked all the way until he got fired. So if he had PTSD and he was able to be working, then all of a sudden he can't. That goes again to intentional underemployment. He specifically told this court that he wasn't looking for a job or even tried to in June, July, August, September, and October. He didn't start till November, knowing he had been fired. And in fact, he said, I applied for a hardship because I knew this was coming in June. So he had the afterthought to think ahead to pay the mortgage, but he didn't think ahead of the child support that he needed to pay or any other debt that he may have. He has testified that he's living off with family members. I have a very hard time. His father's in the hospital, his mother's retired, and he expects us to believe that he's getting somewhere in the tune of over $3,000 a month from everyone for the last 7 or 8 months. He didn't even make an effort, Your Honor, and he lives in a $1,000 apartment. If the judge would allow my client to testify, she lives in a $900 apartment and the kids live with her full time. He's paying more than she is, and yet he only gets the kids on weekends. And he specifically asked to live in the home. So he had a place to live up until the sale. He decided to vacate the residence and go and start paying rent, Judge, even though he had a house to live in.
Why did he do that? That's an interesting question.
Judge, actually, because they agreed that he would vacate the house in August. So he had to get an apartment so they could put the house on the market and it could be for sale. So he stayed there until I believe it was the end of August.
That was by mutual agreement that they agreed that?
No,
Or-
Judge, that was not an agreement.
Is that something
I have
that?
the emails from Ms. Diaz where she was requesting that he move out of the house so they could place it on the market. And he did that, and he got an apartment. He hasn't been living at the apartment this whole time. She's also mischaracterizing his testimony. He was not working up until the time he got terminated. He was getting paid, but he was off work. PTSD claim. So that's also not true.
Was he working when he was with you? Yes or no?
So, if you want to get into it, he was a witness to one of his officers getting shot and killed. That's what's led to the PTSD and the other issues he's had.
I suspected that, Mr. Davis, and I was trying to be, sensitive about asking that question, but since you brought it up, I guess that was a.
Well, it's out there, and that's,
But Your Honor, that was exactly my point about asking the previous DWIs. He's blaming it on this incident when he already had these kind of problems before the incident, years before the incident. So now he wants to say, oh, because of the incident, I've had problems and I started drinking. He had DWIs way before this incident, Judge. This is not his first or second DWI. He's managed to get him expunged.
That's an issue for the DA's office for them to take into consideration whether how they want to proceed on this DWI.
Judge, not if you're considering underemployment or intentional underemployment based on his PTSD. If the court wants to say based on this PTSD, then I would argue with the court that that's not relevant because he's saying, I got a DWI because I was having trauma, yet he had DWIs before this trauma.
But
So
when
I
did he
understand
say
where the
that?
court
He
is
never
saying.
said that. The problem with that is he never said that.
He did get a DWI in
I'm
2000.
not saying that.
In 2000, he got a DWI. He got that case expunged, and he got another DWI in July, correct? Or June?
No, it was the
January, Judge.
yeah. Yeah, it was early part of 2021 or 2020. Yeah.
2021.
Yeah.
Okay. Do we have the date on when he got that one? The DWI?
No, Judge, I'm sorry. I only have the date it was filed.
Which was in June.
Yes, Judge, in June.
All right, please don't tell me it's in county court 8.
It's a D court, Judge.
Yeah, I think it's in Judge.
It's in the D court, Judge. It's in the D court, Judge.
Okay.
But Judge, our argument here, since Mr. Davis seems not to be clear, is that he's intentionally under or unemployed, Judge. He claims that he's made all these applications, but he may or may not be able to find them. He may or may not talk to these people. The people that he's talked to are hiring at $12 an hour. And for the type of training and education that he has, Judge, there's a lot of other jobs that he could get hired on that pay at a minimum 15, but he wants to keep going lower and lower. If he's honestly making a $12 an hour, he wouldn't even be able to make the payments that he's living on right now. Just the mere payments that he's telling me is $2,180, Judge. That wasn't including the mortgage that he had been paying because we couldn't find any evidence that those payments were delayed. But I realize that that's an issue for another time, Judge.
How much is he currently paying in child support?
Is he ordered to pay or does he actually pay?
Ordered to pay.
$1,290. The court said he would only have to pay $1,000 until the house was sold, and that she would get the remaining $290 from the sale proceeds of the home. I apologize. No, that he would start paying it after the house was sold, because at that time he was also paying the mortgage. That was a part of the court's consideration because he was paying the mortgage of $1,716. And so the court said, well, once you sell the house, and Judge, I want to make something clear. We asked him to move out of the house because the court may recall that I tried to get a hearing because he refused to cooperate with selling the home. And so the only way we could get him to, so they could show the house because he refused to cooperate, was to get him out. So that's why we finally said, well, then kick him out because he refuses to cooperate. The court ordered the house to be put up for sale since March. They weren't able to do it till August or September after he moved out because he refused to cooperate. That's why we had to get him out.
He was also in an inpatient treatment for most of the summer of 2021. So this is, again, just totally mischaracterizing what's going on here. First, 5 minutes ago, she was saying, oh, we never asked him to move out of the house. Now there's—
No, I said it was never an agreement. No, Judge, I said it wasn't an agreement. We were forced to get him. We forced him out because that's the only way we could sell the home, Judge, because he refused to cooperate. And as he just said, he wasn't even in it half the time, but he refused to move any of his stuff or clean it up and would not let my client go in. So
because
we
he
had
was
to do this.
In an inpatient treatment facility.
For what?
And he could,
for treatment
Judge,
for substance abuse and PTSD.
Okay.
which are all intentional acts, Judge. They're all intentional acts. And I think part of the claim
How
for
in the
PTSD,
world is substance abuse and PTSD an intentional act?
no, substance abuse is, Judge, you take drugs voluntarily, nobody forces them down your throat. So if he's claiming substance abuse, then he was intentionally abusing drugs.
All right. The only issue that I have at this point is trying to determine the amount that he is entitled to and whatever offsets that he's entitled to since, I guess, September, when Ms. Diaz, you requested that he move out of the home. That's really the only issue here.
Well, we requested that our agreement was, since he wasn't cooperating, then move out. Do one of the two.
Correct.
And he did.
Right. So he did. So So he's entitled to some, and again, I'm having some difficulty because I don't have anything in front of me, but based on what you said, Ms. Diaz, his child support was $1,290 based
Yes,
on
Judge.
his income, right? That
Yes.
Mr. Davis is claiming that it should be reduced down to 300. Is that right, Mr. Davis?
Correct, Judge.
Okay, because
Starting July
300.
1st.
well, that's what Mr.
But
Davis said. I'm not saying I'm going to grant it. I'm not saying I'm granting.
Okay.
I'll tell you right now, I'm going to deny it. Okay, so
Thank
then
you.
yes, you can back off because I don't need the, I just need I need to work this through it. All right.
Correct.
So it's going to stay at 1290. I'm going to deny the request to reduce it. All right. And it's going to come out of the proceeds. Okay. I just need Mr. Davis and his client to get compensated or to get consideration for the time that you asked for him to move out because shouldn't have to pay a mortgage and rent. Okay. So let's figure that out. And it's real simple.
And my understanding
Yes,
that was September 1st.
Whatever it is. So September, October, November, December, and January, 5 months.
Yes,
Yes,
Judge.
Okay, figure that out. I don't know, because I don't know those numbers.
But when you say consideration, what kind of consideration is the court asking for?
Well, because it's a mutual debt, right? It's a community debt. And he wasn't
Okay.
getting the benefit of living there.
But
Right.
Your Honor, I believe he also testified that he wasn't paying it. So it's
Doesn't
already
matter
going,
It doesn't matter whether he was paying it or not paying it, Melinda, is going to be deducted from the community, from the proceeds. So they're equally getting, they're equally paying for that. They're equally being punished for that. But because it's selling, the mortgage company is going to get paid off, right? So it doesn't matter.
Right. But
Okay.
Judge, he already said he got credit for that. That's what I'm trying to tell the court. Why are we giving him more credit? It's already included.
Okay, well
He
then,
said he didn't pay it. He
correct,
wasn't paying it.
correct. So if he didn't pay it, then he
He
shouldn't get, yeah, that's it. It's already a wash.
Correct.
Right, right.
Okay,
That's why I was telling the court he
So the
shouldn't get the
principal
credit.
and interest just went onto the back of the mortgage.
that's right.
The
Okay.
buyer's paying off the mortgage.
Correct. The buyers are paying off the mortgage. And so thankfully it didn't get repossessed because they were able to salvage it through some sort of program. Right?
The forbearance.
Yeah, the
program.
forbearance. All right. And
We're hoping so. Judge, quite honestly, we don't have that information. We believed he was paying it, but I don't have one way or the other to determine that, Judge. That's why I was asking, because he would tell her I'm paying the mortgage. So I don't know if he actually paid it or not. And she's not on the loan.
it's in his best interest to show that he did, so he could get compensated for it, right?
Right. He paid it up until he got terminated, Judge, which
In June.
was
Yeah, okay. So at the end of the day, 83,000 is going to both of them, but she needs to get paid for the child support that she never got paid from whenever the orders were taken out.
I think it's
Yes.
48,000, right?
From my understanding, Judge, and if you,
I'm sorry, 48,000, yes. I was looking at his retirement.
well, no, Judge, I believe that that's the amount that they're each getting. Is that,
Yeah.
that's
I
the amount they're each getting.
I gave you the number of 83,000 because I had written that down, but that's his approximate retirement account. But you're
Right.
It's 48,000, 48,000.
Well, from what, in speaking to the Realtor, Judge, I believe it's 49,000 if you want to cut pennies, but they're supposed to each get 49,000 this Friday if they close.
And submit an order so that she can get reimbursed for her child support.
Right, and that's exactly what we were asking, and the amount that if you would total the child support and the medical that he hadn't paid anything towards would be $11,875.60.
Okay, so deduct that from his amount, add it to hers, and there's your accounting,
Yes, Judge.
right?
And going
Yes, Your
forward,
Honor.
Judge,
I'm sorry?
I understand you're denying our motion to modify the child support in July the 1st, but going forward, how are we going to deal with the child support? Because we got a figure that's not supported by the facts. He's not making that kind of money. He's worked, as he testified, as a police officer for 17 years. So he has all his training and experience for the most part.
I will make an order that effective today, because again, everything up to today was working off a previous order that the court is going to find that I'm going to hold to that order of 1290. So effective today, Mr. Davis, the court will find that your client is entitled to a modification of the child support effective today.
Okay.
Based on his current wages, which is minimum wage.
Well, Judge, he's not working, so you're gonna do it on an unemployed person?
Well, he's not working, yes?
I understand, but that's our argument, is that he's intentionally, Judge, you go to Target, you can walk in and get a job at $15 an hour. He testified he's not even looking there. He instead goes and applies somewhere that pays him $12 an hour, Judge.
Okay, go ahead.
The evidence is not that he's intentionally unemployed. He was terminated from his employment. So that's
based on an intentional act.
Right, but he's also suffering from PTSD, and I mean, I'm taking that into account.
And
Judge,
now he's trying to get back in the workforce.
But Judge, I don't think we have any evidence that the PTSD is keeping him from getting employed. He specifically said he did not want to get employed because he was still on that FMLA or whatever thing it was. So he was still working. And so he didn't say the PTSD doesn't allow me to get a job.
I think we're a little bit confusing.
Judge, I believe what he said is because it scares a lot of employers because I had unlawfully carrying a weapon. That's what he testified to.
Oh, that's an automatic charge that comes with any law enforcement officer who's arrested for a crime. And those things get dismissed as part of the plea agreements. We all know that.
But I'm going based on his testimony of what Mr. Davis is saying. He never testified because I have PTSD, I cannot work. No, he said it scares employers away because of that charge. That's what he testified, Judge. Those were his words. It scares employers away. So he's claiming he can't get those jobs because of that, Judge. And yet he testified that he didn't even try looking at all these other places. And he doesn't have a conviction, Judge. So they mostly ask you for a felony conviction. Most employers, especially a place like Target or Walmart, they don't ask, do you have, what charges do you currently have pending? It's usually felony charges, Judge.
There's no evidence.
But there's no evidence otherwise.
Well, there is evidence of this. My client testified that up until the middle of June of 2021, he was employed by Mission Police Department. He was not working because he was on the FMLA, the sick leave, the extended sick leave under their collective bargaining. So he was still getting his salary, but he was not required to report to duty. In June, I believe June 14th of 2021, he was terminated by the chief. That doesn't mean just because the day the chief decided to terminate him, his PTSD went away. He was still under treatment, and his treating physician, my understanding is to this day, has not cleared him to go back to work. Probably as a peace officer, but in lieu of the situation, Mr. Garcia has testified at the end of October, November of last year, he did begin actively seeking employment. He also testified that, and it's been probably a long time since any of us had tried to get a job, it's different than it was back then, that you do it online and you do the application through a portal. It's not that he emails the application, it's that you fill in the blanks on a portal and then you wait for a return email. So he doesn't have copies of all these documents because you just log on to the particular company to the section where they're hiring, and that's how he's making his applications.
How would a person know to go back and check with anyone if they have no reference of who I've applied for? We know that that's not true, Judge. You have to have some kind of record. I applied here, and he just said that he had to report it when he was doing unemployment. He has to have some kind of evidence.
Real quick, Ms. Diaz, we're not finalizing this divorce today, correct?
No.
Okay.
No, we're doing child support, Judge.
Okay.
But my argument is that it should not be at minimum wage. At a minimum, it should be at $15 an hour, Judge.
But there's no evidence. I mean, that's just because you, Ms. Diaz, have stated that that's what the going rate for employment is at Walmart. I mean, there's no other evidence other than that, right?
Yes.
I mean,
Well, other than him testifying
the
that
governmental minimum wage is still $7.25,
Correct.
right?
Yes, sir.
Judge, if you look at the factors under 154, And when you discuss that, it specifically states about his training, his experience, what his education, what other kind of job would he be able to get? And he'd be able to get a job that doesn't pay $7.25 an hour. Those are usually jobs with people who barely have a GED, Your Honor. This is a person that was a few hours away from a college degree, somebody who has 17 years of experience in law enforcement and training and education. And you want to put him at the same level of somebody coming out of high school?
Well, the
He has
problem is,
training
Judge,
and experience that would give him a higher paying job.
right, but it's all in law enforcement, and right now he cannot work in law enforcement because of the pending criminal charges. So
And he's already testified that the jobs that he's applying for pay $12 or $15 an hour, Your Honor. So we know that at least that's happening. And calling LFD, he more than likely will get hired at that amount. Because I spoke to Mr. Perez that he did not know the last name to. Diego Perez is his name. And I spoke to him. And they said they were waiting for paperwork and more likely he would get hired on Thursday.
Okay.
And he won't be making $7.25 an hour, Judge. And I don't want to have to come back and do another modification based on that.
Right.
then I'm making $12 an hour.
I'm sorry, Mr.
Tell
Davis.
me,
I believe his testimony was the LNF distributor's job was offering $12 an hour.
what the gentleman told me, Judge, is that he would be making, he wasn't sure yet, but he would be making either $7.20 or $9.80 every 2 weeks. And I did the calculation both based on that, Judge.
And how much is
And
that?
if
An
I-
hour?
I'm sorry, sir.
How much does that come out to an hour?
I didn't do it by the hour, Judge. What I did instead was the monthly calculation. If you were to make $2,600 a month and paying $320 for his medical support, it would come out to $478.93 for 2 children at 25%, with a monthly deduction of $364.27 for Medicare, federal taxes, and the OASIDI. That's what that comes.
So we have an option, Mr. Davis. I can reset this case to come back in 2 weeks to make sure that he got that job and see where we're at, or he can accept the amount that Ms. Diaz just proposed. Seems like an offer to me.
Right. Is Mr. Garcia there?
He's off camera.
Yes, I'm here.
Okay.
I'm gonna put y'all in a breakout room.
Okay, Mr. Garcia, did you understand what the judge was saying?
Not entirely.
Okay, as far as modifying your child support, he can go ahead and do it and make it $478 per month at this point. And that's assuming that you're gonna either get the job at LNF or get a similar job paying a similar hourly wage, or hold off and we come back in 2 weeks, essentially for you to tell us whether or not you got that position.
Well, Mr. Davis, I'd rather wait, to be honest, because I had an interview and I was going to get hired the first time around, and for some reason I didn't. I'm hoping and praying I get it this time around, but there's no guarantee.
Okay, then Judge, I guess.
So I can do it.
Status in a couple of weeks on
I
that.
can do it on the 24th at 9:30. And Ms. Diaz, the other order, submit an order to the court so that the realtor can work on the paperwork and get that taken care of. I mean, I don't want them to be tied in together.
I understand, Judge. So basically our motion, his motion for modification of child support will be on January 24th.
Correct.
And so there's no modification in that part thus far. And I apologize, Judge. At what time on the 24th?
9:30.
At 9:30. Yes, Judge. I will submit the order and I'll circulate it first to Mr. Davis.
All right. Anything else, Mr. Davis? Ms. Diaz?
Nothing further, Judge.
No, sir, Judge. Thank you for your time.
Thank you.
Thank you, Your Honor.
All right, that takes care of our docket.